So our opinion,
our analysis,
not legal advice. So it is a big night, okay? Trial Watch is a full catch-up on Clancy. Monday, we only got to the 2 doctors on day 5, and since then we've had the rest of day 5, all of day 6, and today day 7. Then a legal minute that goes deep on something a lot of you asked about, how a parent ends up convicted of murder for a shooting their child committed, and why that's only happened a handful of times in American history. Evidence of the night is the sentence that just came down in that exact case. And a red flag on what's circulating online about how she got out that window and what the actual expert on the stand would and wouldn't say. Sourcing up front, our Clancy content comes from the official court docket and an unofficial auto-captioned recording of the Trial Watch broadcast that is not an official court transcript. Where wording matters, we'll flag it. And I will also say that it includes my handwritten notes that I have taken. And as Nick has seen how I watch the trial, I will watch it, pause, watch, pause, watch, pause, watch, pause. So if it's like a 7-hour video of the trials, it takes me almost double that time.
Let's go.
Segment 1.
Trial Watch.
So Lindsay Clancy is on trial in Plymouth Superior Court for the deaths of her 3 children, Cora, Dawson, and Colin, in Duxbury, Massachusetts in January of 2023. She's charged with first-degree murder. The defense has not disputed that she caused the deaths of her children. Instead, it argues she lacked criminal responsibility, a notice of lack of criminal responsibility, Massachusetts insanity defense framework, arguing she was in severe postpartum psychosis and could not understand what she was doing. The Commonwealth disputes that.
Let's define lack of criminal responsibility, shall we? Massachusetts' version of an insanity defense. Under the, was it McCool? McCall. I always get that wrong.
Yeah, I know.
Under the McCall standard, the question is whether, because of mental disease or defect, a person lacked the capacity either to appreciate the wrongfulness of their conduct or to conform their conduct to the law.
And we covered that Monday.
Yes. Where we left off on Monday, the medical testimony of Dr. Kelly McDonough, South Shore ER, the 82.1 body temperature, superficial wrist and neck cuts, thoracic spine injury, and Dr. David Casewalker of Boston Children's ICU, which was Colin's brain death determination. Life support ended January 27th. We noted the Friday jury view and Judge Sullivan's well on schedule, if not ahead.
Yeah.
They're moving along. And tonight we pick up everything else.
So the rest of day 5, the witnesses we haven't covered. So day 5 actually had 13 witnesses. We covered 2. So here's the rest. 2 more treating physicians for the children. Dr. Michael Snyder, ER at Beth Israel, treated Cora, arrived in cardiac arrest, CPR, and pediatric advanced life support in progress. Ultimately declared deceased. Dr. Andrew Capara at Boston Children's received Colin by MedFlight. Then the Brigham and women's staff who treated Lindsay herself. Rochelle Amid, a trauma-ICU nurse, testified she was assigned to Lindsay's care overnight on a 1-to-1 and that Lindsay coded at approximately 3:30 in the morning, meaning her blood pressure dropped to a level not sustainable with life, and the team began CPR.
1-to-1. Let's define that real quick. A hospital protocol where a patient is monitored continuously, 1 staff member to 1 patient, and not left alone. Used here because Lindsay was identified as a suicide risk.
So the next one they're going to break down is coding. So for those that don't know, in a hospital, coding, they have different, and each hospital is a little bit different depending on what they give each color, but it is hospital shorthand for a medical emergency, typically cardiac or respiratory arrest that triggers an immediate resuscitation response. So again, there could be like a code blue. They have different hospitals, different codes. We just said coding in general.
A second nurse, Megan Collins, testified that after Lindsay was taken off a breathing tube, she became confused and agitated, was picking at her lines and drains, and had to be restrained. ICU delirium, and that improved over the following days. And 2 psychiatrists, different reasons, different days, often confused for each other, Dr. Sahal Shah evaluated Lindsay on January 29th regarding her capacity to change her healthcare proxy from her husband to her parents, and testified she was able to voice a consistent choice.
The healthcare proxy is actually, it's just the person legally authorized to make medical decisions for you if you can't make them yourself. So the rest of day 5 was the chain of custody. So the search warrant block, Sergeant Rose Stoffers and Trooper John Santos, crime scene search, Detective Mark Ferroli and Trooper Leah O'Connell, collection and logging of Lindsay's blood and urine, and Duxbury Sergeant Robert Flynn, scene sweep, flag them as witnesses. Okay, so all day 5 witnesses content here, we have used the transcript to catch, and I will say that when I'm taking my notes personally, I pause because if you've noticed, if you caught any of the testimony as it's live going on, when they take the stand, they ask them to state their name, spell it for the record, and then they give their date of birth. So when they do that, I'm actually making that note myself so that I can spell their name correctly based on how they say it. And I might have to rewind and pause multiple times before I can get it all, but some people talk fast.
A legal point worth flagging: the second day 5 psychiatrist. There's one more day 5 witness, and she matters enough to stop on because her testimony connects to something the defense flagged all the way back on day 1 opening. So back to consciousness of guilt and the definition of that. A legal concept where a prosecutor argues a defendant's after the fact behavior, fleeing, lying, destroying evidence. That shows they knew they'd done something wrong. A recognized category of evidence. What it is not is a person exercising a constitutional right.
So in his day 1 opening statement, defense attorney Kevin Reddington directly addressed the prosecution's use of the fact that Lindsay asked for a lawyer, calling it, sarcastically, quote, "That's rich," end quote, right before walking the jury through her cutting her own throat in front of the mirror as evidence this was not a faked suicide attempt. So the moment that traces to came on day 5, and it was Dr. Gilliam Biswas, a forensic psychiatrist. On January 26th, the day after surgery, she evaluated Lindsay while she was still intubated and unable to speak. Lindsay answered by writing on paper, and that's actually depending on which. Some said she used like a dry erase board, some have said paper, but basically she was intubated, couldn't talk, so she used another form of communication. Asked her mood, she wrote, quote, "horrified," end quote. She then wrote, quote, "Do I have an attorney?" end quote, followed by, quote, "Is my body broken? Are my legs straight?" end quote.
And this is an auto transcript source, not certified. So treat the wording as close, not verbatim, until confirmed against the certified transcript. And so just to bridge my credentials a little bit, from an investigative agent standpoint, this is a well settled invoking your right to an attorney generally cannot be used as evidence of guilt. It is your right to seek counsel, regardless of whether you think you did anything wrong or not. There are narrow context-dependent wrinkles, though. Pre-arrest versus post-arrest, Miranda, impeachment. Those are all nuances when it comes to that. But as a substantive argument that someone is guilty because they asked for a lawyer, no. Not etiquette, constitutional law. It's in the Constitution. If a jury heard it framed as suspicious without a clear instruction, that's a real appellate issue down the road.
Viewed in context, those statements appear sequential, written one after another on the same page during the same medical encounter, while she was intubated and unable to speak. We're not going to tell you what was in her head. Reasonable people may read that sequence differently. What we can say as a legal matter is narrower. A request for counsel standing alone is not consciousness of guilt. Day 6. The stipulation and the forensic chain. So on Tuesday, August 4th, after a colloquy with the court,
Very good.
Judge Sullivan found that Lindsay Clancy made a stipulation willingly, knowingly, and voluntarily. On the record, defense counsel stated it covers chain of custody, the blood, the fluids, the exercise bands, the DNA, specifically to spare the jury what he called, quote, days of testimony, end quote, from custody witnesses.
So definition of stipulation. Stipulation is an agreement between both sides that certain facts don't need to be proven witness by witness. Not a guilty plea. Says nothing about guilt or innocence on the charges. Here, purely about how physical evidence is handled. And that is a gameplay that the defense is doing to help minimize the amount of talking about the blood, the fluids, the exercise bands to the jury. It really is. That's what it is.
I agree, yes, but at the same time, like, I have watched days of this.
And they are just doing it anyway.
Well, it is, I'm sorry. I mean, people may paint her out to be a monster or whatever, but I can tell you as a mom, and I'm sitting here listening, and they are going through like what, you know, all of the things in regard to each specific child. And it is, you know, one person, I did this, and then the next person comes in and says the same thing. And it's like, you hear now for 6 hours
over and over.
And, you know, whether it's a show, whether it's whatever, but you can see her almost like just sobbing
I could
quietly
imagine.
as she hears, you know, the heart was not beating, or, you know, that as, I mean, again, take it as you will, but I'm telling me, like, as I'm watching this, if I was in that situation, I couldn't listen to that all day.
Side note, we were going about our day-to-day the other day, and Lacey mentions to me, hey, do you want to stay up with me and watch some of this? I have the most disdain for this proceeding. The absolute, I understand it's a part of the justice system and it needs to be done. It has to be done. But I don't, me personally, I don't have to be a part of it. I don't have to. In my life and my way of living, I have so much disdain for what is happening with this situation.
But
it's a reality. I have to understand it's a reality.
Yeah, and I feel like the only way that you can elicit change or, you know, things like that is to know. And like, that's the thing. I get not everyone can sit for 7 hours a day and watch this trial unfold, but at the same time, otherwise you're taking somebody else's word for what was said or what was done.
Now,
and
I want to put this through a lens, and I don't mean to cut you off. I do that all the time.
yeah,
but
every time I talk.
Think about this.
Exact.
Think about this. You're putting it through the lens of you. Think about the lens of somebody else who just does not care.
They are the one that this happens to.
That's your lens.
No.
That is your lens.
Because the people that continue to go along in their life thinking, not me, not my problem, not my business, I'm just going to move along. You never know. And you could be in a situation where if, say, for instance, they find that it was medical that led to this. And, you know, maybe one day you are in a situation where you can't get the help you need, or this or that or whatever. You never know.
Yeah.
You never know if, you know, it's your kids that are, you know, going to be away at college and something happens.
I get that. We want to be the most well-informed that we can, and the more experience we have with a situation that could potentially impact us down the road. Yeah. We're more well-informed and we could make better decisions.
Yeah, but there's just too many people that go along in life and they're just like, oh, well, not my problem, not my business.
Or they just react to whatever happens.
Yeah, and they take what people say.
That's called living, man. Livin. One of the reasons we started this podcast, honestly, and doing the lives was because the people that we talk to, the very few people that we talk to, they enjoyed our dynamic between each other, the way we expressed
And that we
each other.
don't always agree
We
on
don't
everything.
always agree because, case in point, Lacey is very much wanting to know about this situation, to be prepared. Me, on the other hand, I'm a fly by my seat of my pants type of guy for the most part, and I'll deal with it when it happens.
Okay. Well, I'm just going to go ahead and say that if we are willing to believe that everyone is all great, good, and wonderful, and everybody does their job to
I
the
don't believe
best of
that.
their abilities,
I don't believe that.
then
You
I
know
wouldn't
that.
have anything to worry about.
Okay, and that's fine. And that's
But
fine.
sadly, we know in too many situations
Yes, we do.
where people are not always doing things with the utmost honesty
and good intention.
intentions.
Yeah, you're right. You're absolutely right. And we hope that in our lives we don't experience that. But if we do,
but if I didn't pay attention to this, I wouldn't know that this kind of stuff goes on. Like, and I'm not saying this specific case. I am saying there have been countless.
Okay, but does that where does that help you as a person?
I don't trust people.
So it gives you anxiety.
Well, I mean, maybe a little bit, but I'm also prepared.
Okay. The rest of day 6 ran the forensic and medical chain. Dr. Christina Carpio, trauma surgeon, confirmed the 82.1 degree temperature and unstable thoracic spine fractures. Lieutenant Joseph Rabbit checked on the children at the hospital, then assisted the warrant. Maureen Hartnett collected stain swabs across the scene. Trooper Jonathan O'Loughlin, fingerprints on the bands and the knives, the resistance bands and the knives. None recovered. Toxicology witness, there were a couple of them, Hillary Griffiths, Lisa Yell, and Alicia Zimmerman. What was and what wasn't in her system, post-mortem screening for the children, and a blood stain pattern analysis, Sherry Crook, whose testimony we're holding for the red flag, because it goes straight at what a lot of you have been debating online. We've seen a lot of debate on the blood stain analyst.
We are going to define post-mortem toxicology. So toxicology testing performed after death. Here on the 3 children, separate from the clinical toxicology done on Lindsay while she was alive. And on that note, I will also say that if you are not following along with the trial, like in real time, you're missing a lot of key things where it's really good to hear some of this broken down.
I can pretty much promise you, you're not following along with the trial like she is.
Day 7.
Today.
We're going to fast forward now. We're going forward in time.
Yeah, we talked about day 6. We're talking about day 7 now.
So this is the wounds, toxicology, DNA, and the nanny.
Eaton Negri.
Yes. A physician assistant at Brigham and Women's testified to a right wrist laceration about 3 centimeters deep requiring 1 suture, and a left wrist laceration about 2 centimeters deep, also 1 suture, with other cuts superficial and closed with steri strips. So you will hear, and again, if you were listening to any of the first parts of the witness testimony, it was repeated quite frequently that they were superficial cuts.
Yep.
And then, they were trying to, elicit the testimony to bring out, well, how much blood was here and there. So you'll hear that superficial and deep about different on the same person. So it's not a contradiction. On cross, the point was made that in a medical chart, deep describes direction into the skin versus across it, not automatically severity. And also on that note, when some of these people were testifying, they were there on the scene and they stated that they only saw on one side versus the other. Some said they saw it in regard to her neck.
Yeah. Some
of the testimony said that they saw it all the way across.
Okay, I'm going to stop you right there because you can claim what you saw. That's fine. You can claim what you saw and testify to it. But I'll tell you right now, from personal experience, when somebody has dried blood all over them,
Yeah.
you have no clue where cuts are. Period.
Yeah,
End of story until you wash the entire area clean of blood.
Well, and that's even in the photos, because they show it and you can see,
you have
the
no
lacerations,
idea.
but she's got blood on her hands.
Oh, it's
And
everywhere.
They talked about the clothing that they had removed from her, and it had soaked into her bra and things like that. So I mean, and again, it was dark. Like, she was outside, so it was dark.
Mm-hmm.
It was, I don't necessarily
With the amount of
fault them,
No.
so to speak, for what they say they saw or didn't see. However, what I was kind of in my head, as I'm listening to this, it was like, regardless, it was a cut.
I hate when those things are said because
I'm just saying they and again, this was the Commonwealth that brought these witnesses, so they were trying to get the point across that they were very minimal, so to speak. They wanted to minimize that, not minimize in the way that they're trying to kind of elicit that
stupid.
She wasn't being sincere in the attempt.
Okay, well, the Commonwealth brought forth a ton of evidence that I got a little glance at today when I was prepping for the stream that had blood absolutely everywhere in that room.
Well, and again, that was one of those things,
this isn't superficial cuts.
But
Sorry.
The Commonwealth did object to some of the photos, and I was just like, I don't understand.
They presented?
No, not that one. It was another one later in testimony. They objected because they're like, well, objection to that, and I'm like, what?
The whole superficial thing.
We can't pick and choose which
irritates the crap out
So,
of me.
anyways, I will say that a large part of what is being, kind of back and forth on social media, even within the courtroom, you've seen it. And I'm thinking, as a juror in this case, they're
gonna latch onto it.
And they tried to say things like, like one of the testimonies, they're like, well, you didn't have to apply a tourniquet, so it wasn't a bad laceration. Well, I don't know that a lot of, I can't say, in my head, I wanted to be like, that should have been,
like I said before,
not allowed, because you don't know how many people actually get, I don't know.
So frustrating for me.
I think they're trying to put on that this wasn't really her trying to kill herself. Yeah.
Of course, that's their job. That's what they're trying to do.
Again, and because I looked at it and I was like, that one, I know, there's one, it doesn't necessarily look. And again, it's a picture, and most of these, I'm like, what printer are we using to print these photos?
But they said 3 centimeters deep, requiring 1 suture. That's an inch, ladies and gentlemen. That is nearly an inch. Now, if you have an inch deep laceration in your body, that is not superficial.
Again, I don't necessarily think that, unless we're talking about a doctor or a trauma person that is treating them.
Let's say 3 centimeters, where we don't live in a nation that uses the metric system, so 99% of people have no idea how big 3 centimeters is. Well, let me tell you, ladies and gentlemen, it's nearly an inch.
I will also say that during some of the testimonies, they have pointed out, and I don't remember who exactly said it, but they were like, well, she didn't have to have any sutures or anything until the next day. Well, most people know in hospital settings that if someone comes in a trauma situation and they have something that needs sutures, but they've got, they're missing an arm, the suture on the toe might not be as important as fixing this, the arm that's missing.
I'm going to say this, and then we're going to move on to the 2 toxicology witnesses. I just wish, and I would hope, but honestly, the government would just tell the truth. State the facts as they are, not how you want them to be interpreted.
I agree.
That's all.
If the facts of the case are what they are, then you shouldn't have to elicit or try to persuade.
Yeah.
You know what I'm saying?
Sorry,
it should just be the facts of the case.
This case just irritates the
and
piss
let
out
the
of me,
people actually interpret the facts of the case without you giving them your interpretation.
Yeah. So the two toxicology witnesses, Nicholas Roberts, a former state crime lab analyst, and Justin Brower of NMS Labs, testified her prescribed psychiatric medications were largely a therapeutic level, with one exception. I don't know the name of this, but it's spelled Quetiapine. That medication elevated, but far below overdose levels. Brower's opinion, the levels were not consistent with an overdose. A DNA analysis, Katrina Stashin, we'll try that, testified to the lab across, gosh, I can't read right now. I'm so sorry. I'm just, this is how heated I am about this whole situation. It's so frustrating to me.
He's worked up.
Okay, let's...
Testified to the lab process and that her controls and review passed. And Lindsay's former nanny, Elaine Rossi, testified, describing Lindsay as attentive and safety-focused with no disclosures of harmful thoughts toward the children during her time with the family. According to multiple media reports today, she described Lindsay as a, quote, wonderful mom, end quote.
See, that's why we're together. She helps me out so much.
Isn't that sweet? So, still open, the promise we made Monday. Monday, we told you that we would not characterize the defense's emergency motion, numbers 152, 153, and 154 affidavit disputing the search date evidence until we could see a ruling on the docket ourselves, keeping that promise, and we pulled the docket today. As of the docket current through today, August 5th, there is still no written ruling on the emergency motion. And there is also no ruling on the defense's limited testimony motion number 138. The jury instruction motion, which is number 118, remains under advisement, meaning the judge hasn't taken it under consideration, or has taken it under consideration, but it is not decided. Between Monday and today, the only substantive docket entry is the stipulation. The trial is simply moving forward through testimony.
Straight off the official record, docket pulled today. Primary. Nothing decided on any of these three. We're not characterizing any as granted or denied.
Correct. We will continue to our next segment. Segment 2, the legal minute. When a parent is charged for a child's crime. You just refrain from.
Okay, I am going to refrain from a lot of my commentary with this.
Yes.
And I am going to read.
If you want to talk, you can just talk about the legal part of it.
Okay. So legal minute.
This is the kind of thing this whole show exists to do. So take something that sounds impossible, a parent convicted of murder for a shooting they didn't commit, and walk you through exactly how the law gets there. Because last week, it produced what has been reported as the first murder conviction of a parent arising from a child's mass shooting following the Crumbley parents' involuntary manslaughter convictions in Michigan. So the backstory. On September 4th of 2024, a 14-year-old opened fire at Appalachia High School in Winder, Georgia, killing 2 students and 2 teachers and wounding 9 others. His father, Colin Gray, had given the AR-15 style rifle used in the shooting as a Christmas gift, despite documented warning signs, including law enforcement interviewing the family a year earlier about online threats. Last week, a jury having already convicted him, the father was sentenced. We'll get to the sentence itself in evidence of the night. Right now, we want to explain the law that made it possible.
How does a negligence case become murder? The actual mechanism itself. Here's the part that trips everyone up. The judge repeatedly said this was a case about negligence, not intent. Colin Gray was not accused of planning the shooting, carrying it out, or being present when it happened. So how is that murder? The answer is a specific piece of Georgia law, and it's worth understanding. Second-degree cruelty to children in the state of Georgia means causing a child cruel or excessive physical or mental pain through criminal negligence. Note the key word, negligence. It does not require that you intended to hurt anyone. Next, second-degree murder in the state of Georgia. A charge Georgia's legislature created specifically to fill a gap, causing a death irrespective of malice, meaning without the intent to kill, while committing that second-degree cruelty to children offense.
So here's why this is an important statutory distinction. So Georgia felony murder ordinarily requires proof of an underlying felony, while second-degree cruelty to children is specifically based on criminal negligence. Georgia created second-degree murder to address a death resulting from that particular negligence-based felony, meaning the state can reach a murder conviction without ever proving the person intended a death. That is how a father who was found negligent, not malicious, ends up convicted of murder. Not a loophole, a statute built for exactly this. So we're explaining the general structure of Georgia's statute. We are not offering a legal opinion on whether it was correctly applied to Colin Gray. That was the jury's job, and they returned their verdict in March.
So is this precedent? Is it going to become precedent? Be careful with that word, because binding versus persuasive precedent, binding precedent is a ruling from a higher court that lower courts must follow. What's happening here is different. A trial court conviction doesn't bind any other court. What it does is serve as a persuasive template, a model other prosecutors can point to and follow, influential, not mandatory. So when you hear this case called precedent, hold that loosely. The real story is the prosecutorial trend, not a new rule of law.
So in 2024, James and Jennifer Crumbley became the first parents in the country convicted over a mass shooting committed by their child in Michigan for involuntary manslaughter. Colin Gray's case is the second homicide prosecution of its kind in the nation, and notably a conviction for murder, a step up from manslaughter. The judge himself called it the first case of its kind tried in Georgia, and the second he was aware of nationally. So prosecutors are already watching a next case. A Wisconsin father, Jeffrey Ruppnow, charged after his daughter's December 2024 shooting, though he faces a weapons charge, not homicide.
You know, if you line them up, you can see the arc. Misdemeanor, reckless conduct pleas a few years ago, then manslaughter with the Crumbleys, and now with Gray. Murder with Gray. Each case stretches the theory a little further. That's why the judge here called these cases divisive on the record. The genuinely open legal question, the one reasonable people land on different sides of, is how far this net should reach. Our job is not to answer that for you. We have our opinions of it. We're not going to state them here on this.
Evidence of the night.
Johnny on the spot with it.
The Colin Gray sentence.
So we just walked through how the law got there. Here's what actually came down last week. On Thursday, July 30th, Barrow County Superior Court Judge Nicholas Prim sentenced Colin Gray to 15 years in prison, concurrent sentences on 2 counts of second-degree murder, 2 counts of involuntary manslaughter, and lesser counts. Prosecutors had sought 80 years. The defense had asked for 10. The judge was blunt about the nature of it, on the record, addressing Gray directly.
Quote, "It is clear you failed as a parent," end quote. Judge Prim said, quote, "You were convicted because the warning lights were flashing brighter and brighter and you didn't get him help and you didn't remove his access to the guns," end quote. He added that if Gray had used gun locks or removed the ammunition, quote, "you wouldn't be here today," end quote. But he also drew the line our legal minute was about: negligence, not intent. So, quote, "You didn't intend to commit these crimes that you've been convicted of," end quote, Prim said. Quote, "But the loss here is profound," end quote. He described the difficulty of sentencing a crime of negligence and said he had to distinguish the father's acts from what he called the, quote, malignant heart, end quote, behind the sons. So this is secondary sourcing, and actually HP wire level. The sentencing quotes are carried identically across the Associated Press feed, which is PBS, HuffPost, WABE, plus CNN, the Atlanta Journal-Constitution, Axios Atlanta, and Fox News, all consistent with on-record judge quotes. We were not able to independently pull the case number. However, this is corroborated press, not a self-pulled docket.
Okay, 15 years when the state asked for 80 and the range ran to 30 per murder count. That's the court landing much closer to the defense's number. Read alongside the legal minute, it makes sense. A judge who kept emphasizing negligence over intent sentenced like it. The law let them reach a murder conviction. The sentence reflected that they still saw a meaningful difference between the father who failed and the son who fired. Segment 4.
I'm so nervous to what you've done.
Red flag. What the internet wants to know versus what the expert said. A lot of you have asked us to weigh in on this, so we're going to.
Carefully. Here's what's circulating. Online, there's been an ongoing debate about how Lindsay got out of that second floor window. People measuring window heights against door frames from photos, arguing whether she went out feet first or head first, trying to reconstruct the
mechanics. Trying to reconstruct the mechanics
of the exit from the images that are public.
So let's do what we do. Go to the actual report, go to the actual expert testimony, and see what it can and can't answer. On day 6, the Commonwealth called Sherry Crook, a supervisor in the crime scene response unit at the State Police Crime Lab. 18 years, a supervisor, 26 at the lab. A member of the International Association of Bloodstain Pattern Analysts, qualified as an expert more than 10 times in this Commonwealth. If anyone in that courtroom could answer the internet's question, it's her. So let's listen.
Are you able to look at the stains here and the drip pattern and tell whether there was any movement or in what direction the movement was?
We can't tell what type of movement there was because they're circular stains. The only thing we can say about this is for a drip pattern to be formed, there has to be a stationary blood source. So you have to say it was your finger. You would have to stand there for a while and allow the blood to drip out into each other, causing that drip pattern. So we know, or I've deemed that there was a period of time that the blood source was in a stationary position, causing that drip pattern.
And the amount of time that it would take for that amount of blood to pool, would that be dependent on the wound and how it was bleeding at the time?
Correct.
And you can't tell that from the photograph, correct?
I cannot.
And you can't tell that from the photographed, correct? What the expert said versus what they can't say.
So, transfer stain. In bloodstain analysis, a stain left when a bloody object or body touches a surface, distinct from splatter or projected patterns, which are created by force flinging blood through the air. So Crook classified the stains on the shingles to the left and right of the bedroom window as transfer stains, meaning something bloody made physical contact with that surface, not a pattern projected by force. But here's the part that actually matters for tonight, what she would not say.
And that goes to the clip that you just saw and heard. On more ambiguous stains, Crook testified in her own words. We can't tell what type of movement there was. Asked whether she could determine more of the photograph, and she said, I cannot. Her bottom line on those stains was that all she could say is that something with blood on it touched that surface and nothing more.
Put plainly, The expert specifically declined to extend the evidence beyond what the stains could establish. That's investigator discipline, and it's the whole point.
Now, we have a little guardrail that we need to put in. There's an auto transcript source that you just saw from that broadcast. It is not certified transcript. It is just closed captioning. The substance is solid, but treat these as close paraphrases of her testimony, not exact quotes, because it's from YouTube. It could have been manipulated. We have to take it for what it is. So we don't want to put it out there as absolute fact that this is what it was said.
And until you get the actual transcript from the court.
So it's a little disclaimer that we put out there so that, we are covering our podcast, and again, this is our opinion, our analysis.
Not legal advice or forensic advice. But here's the red flag. The single most qualified person in that room to answer the internet's question, how did she go out that window, got up on the stand, under oath, and declined to answer it because the evidence doesn't carry that far. She told the jury what the stains prove, contact. She refused to tell them the thing everyone online is trying to reverse engineer from photos. The movement, the sequence, the how. If the expert with 26 years and a bloodstain certification won't run past what the evidence shows, neither will we. That's the standard. We'll tell you what's confirmed. We won't hand you a reconstruction the witness herself wouldn't give. This is exactly the discipline we're trained on. So the evidence answers the question it answers. And the temptation always is to stretch it 1 inch further to satisfy the thing everyone wants to know. The red flag is when you quit getting on here trying to take your ladders out your back window and see if you can calculate the distance.
That's
and
science.
That's what people are doing. And then they're pulling these clips off of the internet and they're taking it and they're saying, well, I used my ruler.
Yes.
And
the red flag is don't pay attention to the reconstructions. The testimony she gave is what she can give.
Correct.
Yes.
And that's it. That's the bottom line.
Yep.
Like, she can't give you the answer because she wasn't in the room. And she can tell you that the evidence can only give you this answer.
Right.
But people don't want that.
Of course.
And it's not, they don't care necessarily.
They want to stretch
about this.
it.
They want to say, well, I observed it and I think that she threw herself feet first.
Yeah.
Okay, well, that's what you think.
All right, so segment 1, we covered the trial watch, the Commonwealth versus Clancy, week 2. In our segment 2, we had the legal minute, which a parent charged for a child's crime. Evidence of the night in segment 3, 15 years in the sentence, which covered information from the legal minute. And in our red flag, segment 4, what the evidence can't say. This has been our opinion,
Our analysis.
not legal advice.
This is The Particulars, and we are live Monday, Wednesday, Friday on TikTok at 9 p.m.
Headlines in.
Details begin. We will see you Friday at 9 o'clock to continue the trial watch, and we will see what other, legal minute and evidence of the night and red flag we can come up with between now and then. So keep walking the cases with us. We'll keep walking as long as you'll walk.
See you Friday.
Have a good night, everybody.